And just a reminder, each of you have been given 20 minutes to make the argument. Mr. Fraser, you are the appellant, so you could reserve up to 5 minutes for rebuttal. And what do you wish to do at this time, sir?
Good morning, Your Honors. I wish to reserve 5 minutes for rebuttal.
Excellent. And whenever you're ready, Mr. Fraser, please proceed.
Okay, thank you, Your Honor. Good morning, everyone. It is really an honor to be here today before this court. We are here, I represent Mr. Christopher McCubbin, the appellant in this case, and we're here on an appeal of the trial court's denial of the former husband, Mr. McCubbin's motion for rehearing, arguing that the trial court improperly modified parental responsibility, which neither party had requested, which was not noticed for hearing, and which Mr. McCubbin did not consent to. I'd like to begin with a quick factual summary of what has led us.
Mr. Fraser, there's no need to go through the facts. Let's zero in on the issue of consent, okay? Because in looking at the order, the trial court's order, the court made a specific findings that that the issue of modification was tried by consent. And it says here that both parties request that this court modify the parenting plan. So going back to the actual hearing, there was a hearing on October 31 and December 6. My understanding is that both sides said, hey, the current way of doing it doesn't work. Both sides acknowledge that. It doesn't work, it doesn't work. And so looking in the record, there's a statement from the former wife's counsel, basically says, Judge, it's not working. Mr. McCubbin is not accepting any responsibility. I'm asking for a modification of the time sharing and parental responsibility that would shift that right to the former wife. Then later on, again, it said, you know, he hasn't exercised shared parental responsibility. We're requesting sole parental responsibility at a minimum, ultimate decision-making. And then in response to that, the former husband didn't even object to this. All that he instead said, he acknowledged that there's issues, and then he set forward a parallel parenting plan. Why isn't this, given this scenario, going back to the record, why hasn't this been tried by consent, sir?
Yes, Your Honor, thank you. Well, there's a few cases that illustrate why this would not be considered implied consent. As a threshold matter, these were just arguments by counsel, not actual evidence presented for the court's consideration. And the issue isn't necessarily whether or not Mr. McCubbin objected at the time, so much as if he objected at the time of the error, that being the court's entry of the order modifying parental responsibility. The first district has an interesting...
If I may, Mr. Fraser, sure. My understanding is you have both sides saying the current state of affairs doesn't work. And you have one side that says, this is what I'm asking. Both sides agree. Both sides want to modify the current thing because both sides acknowledge and both sides agree the current state of the affair is just simply not working. So this is where I guess I'm having trouble with. Both sides acknowledge that. You have specific things mentioning the term, repeated, former wife specific and repeatedly requests a sole parental authority. The former husband basically saying, yeah, we're agree with this and performing, and they suggesting a parallel one. And so it's out in the forefront. Both sides agree of that. Isn't that consent?
It is not, Your Honor. Consent, to find implied consent, the court would have to find that the issue was litigated at an evidentiary hearing, which it was not done here. Respectfully, the purpose of this hearing was to determine whether or not the former husband had complied with the trial court's orders in cooperating with parental coordinators, guardian ad litem, and the child therapist. They were there on the former wife's motion for an order to show cause, which never requested any kind of modification. And while the former husband did request a modification of the parenting plan in his supplemental petitions, those were based on a request for modification of child support and time sharing, respectively.
Well, Mr. Fraser, though,
yes,
looking at the transcript of the hearing, there was some direct testimony taken by the former husband's lawyer that asked him about this parallel, right, kind of plan, right?
Yes, Your Honor.
So that kind of testimony was solicited from the former husband's counsel. And I guess in looking at this, I from the record, it does appear that the parties did stipulate to some sort of modification of the plan. I guess the question is how broad was that stipulation? And so whether or not in modifying a plan, certainly a court could modify a plan without changing the responsibility portion of it, correct?
Yes, Your Honor.
Okay, so we need to hone in on whether or not there was consent as to the issue of sole parental responsibility. And and it's hard to say when you're hearing the argument of counsel why nothing was objected to in opening when those arguments were being made.
Well, Your Honor, those questions and arguments were relevant to the matters that were properly noticed before the court. Parallel parenting refers to the way that the parties communicate, which in this case wasn't reasonable due to their acrimonious relationship. It doesn't necessarily refer to the decision-making authority that's inherent in parental responsibility. The Third District Court of Appeals actually had a very interesting case with similar facts. Dysart v. Hunt, citation 383 Southern 2nd 252, decided in 1980, where the court mentioned that you only find implied consent where someone fails to object to questions and answers irrelevant to the matter that are properly noticed before the court. The matters noticed before the trial court was whether or not the former husband was complying with the trial court's orders to cooperate with these experts, the coordinator, the therapist, etc.
And we don't have anything in the show cause order or any sort of notice that said that the issue of the parental responsibility was going to be tried.
No, Your Honor, not in the former wife's request for a motion for order to show cause filed back in August 28th, 2018, not in the trial court's order to show cause acknowledging that on October 10th, 2018, and not in either of the notices for the hearings filed respectively on September 25th, 2019 and November 5th, 2019. Modification of parental responsibility was not brought up. Parental responsibility in general was not brought up, and decision-making authority was not brought up. This was solely based on whether or not the former husband could comply with the trial court's orders and an attempt to get the parties to work together for the betterment of the child.
And would you agree, Mr. Frazier, that even if something was not noticed, many times, and there's case law is replete, that parties can consent, can agree to litigate an issue that was not noticed. And this is why the case law is saying that was tried by consent. And in this case, in pulling up the transcript, it was very clear that says what was presented to the court is that the parties were unable to co-parent successfully. Then the court went into detailed findings of facts, and this is in the record, that indicates how they were not able to co-parent. And it was brought up that what's the remedy to that? And there was mentioning that, sole parental responsibility, it was mentioned that, but it never once during that hearing where the court is making all of these findings of fact and determining what would be the remedy, there was never an objection when counsel said, well, this is what we want the court to do. The other side could have simply objected, Judge, I'm not prepared. Judge, I object, nothing. And that's why, if looking at the transcript, the court came to the conclusion this was in fact tried by consent. So that's my struggle. I know what you're saying about the cases and case law and the notice, but here, if both sides, if one party doesn't object, and that issue is before the court and the court makes specific findings of fact, how can that not be appropriate?
Your Honor, prior counsel for Mr. McCubbin did not object to the requests for parental responsibility because they had not been noticed that that would be an issue decided. Tellingly, the trial court didn't make any of those findings of fact at either hearing that we've mentioned. This solely came up in the first final order issued on December 12, 2019, which the former husband did object to in the form of his motion for rehearing. Your Honor, he did not know that he needed to object because to him, they were there to determine to what extent the parties could cooperate based on the former husband's alleged failure to cooperate with these experts appointed by the court. And in the case law that we've provided, there's ample authority that says implied consent is not found by failure to object to matters that are relevant to matters properly before the court. Because his issue of whether or not the parties could get along and whether the former husband could actually follow the court's orders, he did not know to object. That was all relevant to the matter before the court. He was unaware that parental responsibility was going to even be decided until the court actually issued their order.
But how about the argument though, when what he says, well, Judge, we're asking for a parallel parenting plan. Why? It kind of undermines the argument that that somehow he was not placed on notice. How do you respond to that, Mr. Fraser?
I understand the concern there, Your Honor, and I agree. The use of the term parallel parenting is a little bit confusing. However, again, that doesn't refer to parental responsibility, which is who gets to make decisions on behalf of the children, who gets to make the major decisions affecting their life. This is how the parties can communicate in co-parenting.
Mr. Fraser,
Yes.
Fraser. So under the statute, there is no thing recognizable called a parallel parenting plan. Am I right? This is something that's that has sort of been created, and so it's really either co-parenting or sole parenting, and then the courts, well, the statute allows that there be, for certain aspects, let's say education or medical, that there could be something called ultimate decision right making.
Correct.
As to a specific item. So as to the testimony that was solicited by the former husband, this parallel parenting plan, I'm trying to understand it. It appears there was some sort of stipulation. And if there was a stipulation, then on revisiting or modifying the parenting plan, my question is does that, could parties stipulate, or could there be implied consent as to like ultimate decision-making authority or something on a specific, like education or medical, but would there have to be like specific issues, like separately stipulations? I mean, if parties stipulated, Judge, you can change the parenting plan, does that mean a judge would have the right to change every aspect of the plan if they gave that general stipulation to the court?
It does not, Your Honor. Just stipulating to modifying one aspect of the parenting plan does not allow the court to modify all of the parenting plan. The parties still have to be put on notice of the specific portion to be modified so that they can gather evidence, gather witnesses to put a case on to argue that the modification is in the best interest or not in the best interest of the case may be.
And is there anything in the record where well, obviously there wasn't anything as far as to let the court know that we're both agreeing to allow the court to modify any portion of the plan, is what you're saying. There wasn't any sort of agreement to do that at all. It just was in the former husband's supplemental petition.
Correct, Your Honor. And this court actually did bring up a similar issue in the Stover case. In that case, the appellee requested a modification for time sharing that would require supervised time sharing for the appellant. What the trial court did is restrict all time sharing as opposed to simply requiring supervised time sharing. This court previously held that the appellant had no notice that this court would even consider limiting the time sharing in such a fashion, even though there was a modification proposed. It just wasn't the specific modification that the court granted in relief. This court actually reversed it, saying it was a due process violation, a fundamental error requiring reversal.
And Mr. Frazier, you still have 1 more minute to go to your rebuttal. And if you're in a good point, you want to save the remaining for the rebuttal, or do you wish to go forward?
Your Honor, I would like to reserve for rebuttal. The only thing I would like to bring to the court's attention is that we've got ample case law cited in both the initial brief and reply brief, stating that this kind of modification on a specific issue that was not requested by either party is a due process violation constituting a fundamental error. We'd argue that Mr. McCubbin did preserve the argument by timely objecting to it by way of his motion for rehearing, and that he did not consent by failing to object to matters that were properly noticed, whether or not he could cooperate with the other parent by following the trial court's orders in cooperating with the parenting coordinator and the guardian ad litem.
All right. Well, thank you, Mr. Frazier. Then you basically have 4 minutes for rebuttal, and
Thank
we'll
you.
have that time. Thank you, sir. I'm going to add, wonderful. You muted yourself. Mr. Donovan, go ahead and proceed with your argument, sir.
Thank you. May it please the court. My name is Chris Donovan. I'm here on behalf of the appellee, Jamie Goss. The argument in the answer brief argued for affirmance on 2 reasons. 1, lack of preservation, and 2, the fact that it was tried with consent. Because the court's questions in the beginning seem to suggest they're more interested in tried by consent, I'm going to begin there for my argument. This case was in fact tried by consent because it was raised not only by Ms. Goss's trial counsel during opening and closing without objection, but it was also raised by Mr. McCubbin in both his opening argument and in his testimony and in his closing argument, because in both times he argued and asserted or testified that co-parenting was not working. Co-parenting is shared parental responsibility. The 2 concepts are synonymous. And in fact, not only did he say it wasn't working, he actively advocated for the fix, which in his view was parallel parenting.
Well, but Mr. Donovan, parallel parenting isn't a statutory it's not recognizable under the statute. It talks about co-parenting and sole parental responsibility, right? This parallel is, obviously it's something that does work, but when that testimony was solicited, he talked about parallel. There wasn't any talk about sole parental responsibility, I don't believe, in his testimony on that part. So could you focus in on, irrespective of the legal arguments, the evidence? And I recognize that the merits of that are not being addressed. It's the due process argument. But you had said that this was in the evidence. And we have to be careful here, because just because a topic comes up in a hearing on a different related matter doesn't necessarily mean that that's tried by implied consent. So where else in the evidence was this brought up that you can say that this was by consent?
When you say this, you mean the attempts to change co-parenting in the first place?
Yes.
Well, it was brought up in the opening argument, and putting aside
putting aside the legal argument, because tried by consent, when I think of that, I think of the evidence being tried, not necessarily the legal arguments of counsel.
2 things, Your Honor. I'm going to answer your direct question first, but then also try to explain why it doesn't require reversal on that ground. The first answer is that it was brought up when Mr. McCubbin's counsel was asking the parenting coordinator, is co-parenting, in other words, shared parental responsibility, working? And the parenting coordinator testified, no, it's not working. And then he extended on, and his sort of fix for this problem with co-parenting was to ask, well, would parallel parenting, and again, that's not in the statute, but it's his answer to the co-parenting problem. There was no dispute that parental responsibility, or excuse me, the shared parental responsibility was a problem and was an issue for the last 2 years leading up to the hearing. And the second reason, it's not a matter, this is something that opposing counsel argued both in the brief and a few minutes ago, which may be misdirecting the court a little bit. It's not a matter of when the evidence is presented. That's not the first opportunity. It can be. For example, the Bryan versus Bryan case, which is the case that we cited in our brief, but they relied on in their brief, was a situation where the new issue was interjected into the hearing through somebody's testimony. And that was the first opportunity that it should have been objected to, and they didn't. But in this case, it was interjected in the opening argument and in the closing argument. And they argue that the exception, implied consent that requires an objection, can only happen if it's failure to object to evidence. But that's not what Bryan versus Bryan says. And it's certainly not what Smith versus Smith or Robinson versus Robinson say, both of which say that you must object when the issue or subject is raised. Rule 12.198 also speaks of, quote, when issues not raised by the pleadings are tried by implied consent, they shall be treated in all respects as they have been raised. Even their case, Byers versus Callahan, said that in order to avoid implied consent, opposing party must object to, quote, argument or introduction of evidence. And here, the argument, the request for relief was asked for, asking for modifying the parental responsibility to have sole or ultimate parental decision-making for Ms. Goss was introduced both at the opening argument and in the closing argument without objection. And one of the arguments that was raised for why, one of the alternative arguments for ways why they didn't need to object was professional decorum. But with respect, professional decorum must give way to protecting your client's rights and preserving the error that occurs when it first appears, which in that instance, the first time it was raised, clearly was in the opening argument. And it's certainly, even if professional decorum was an issue, they could have argued right in the beginning of their own opening, hey, wait a minute, Judge, this modifying parenting responsibilities has not been pled. We object to that. We're not ready for that, Your Honor. They could have voiced that objection, as Chief Judge Kuzan pointed out.
Mr. Donovan, so in looking at what was voiced in the legal arguments, I think it's transcript at 1695, it says they're seeking sole or at a minimum ultimate decision-making responsibility for medical and extracurricular activities. Now, the order went on in addition to those two things and addressed, I believe it was education. So if I'm hearing you correctly, then we should be limited to what the legal arguments were made.
To be honest with you, Your Honor, I mean, I believe it doesn't require such a narrow minutia. I mean, I think that once you
okay, but so would sole parental responsibility, can it be divvied up on items such as education, medical, and extracurricular activities?
I believe it can, yes, Your Honor.
Okay, so if someone is saying they're seeking only 2 of how many, whatever the list is that they could actually seek, then certainly somebody couldn't consent to some issues being tried that weren't asked for.
I mean, I think that if the evidence supports that there were also issues regarding education, such as signing up the children for extracurricular activities that were not being conferred with Ms. Goss, I believe the evidence is there to support that.
What about education then? Because that wasn't something that was stated in that statement. So what about education?
I would have to amend or file a supplemental point in the record on that. I don't have that at my fingertips in terms of what testimony was presented with respects to education, which I'm happy to do afterwards. But I do think that I don't think they have found a single case that suggests that it requires such a narrow focus in terms of whether or not something's been tried by consent. I think that simply touching on we're asking for sole parental responsibility, which originally asked for, in a broad sense, all issues on sole parental responsibility, I believe, in the opening argument. And then it was elaborated. And then in the closing, they also mentioned at a minimum these additional points. So I'm not sure that it required and in neither time was there an objection. So I'm not sure that it required the court to look at, well, they didn't specifically say education here. Well, in the opening, they said very broadly. The opposing counsel also mentioned the Dysart case, which is actually a quite illustrative example of a completely different issue being raised. In that case, I believe it was an attempt to reclaim possession of personal property, and that was the only pleading that was alleged. And instead, at the hearing, they suddenly showed up with, hey, we want some damages as well. That's a completely different issue, which is why the Dysart court found that it was not tried by consent. Whereas here, the allegations were, whereas here, in the opening and closing, they specifically asked for this form of relief. I'd also point out that one of the issues that opposing counsel pointed out in the brief was that parental responsibility was not adequately alleged in in the pleadings. But in the case of Cruz versus Domenico, which is something that both sides pointed out, or both cases, or which is a case that both parties relied on, the court noted that in that case, it was a petition to modify child custody as not, and part of the petition to modify child custody, it was alleged that they needed to modify the child custody because shared parental responsibility wasn't working. The other side was making unilateral decisions. And in granting relief, the trial court actually granted ultimate authority over medical and educational decisions to the one parent who was asking to modify. And the opposing counsel alleged on appeal that was error because they had never asked for ultimate authority over medical and educational decisions, which kind of goes to the point that Judge Smith was asking about a minute ago as well. And the court said that in order to determine whether something's implied by consent, you have to look past just what was the prayer for relief in the pleading, but look at the ultimate facts alleged and the issues of proof that were asserted in the pleadings. That were made in the pleadings. And the court found that while specific relief of ultimate decision-making authority was not alleged, there was clearly allegations in the petition that showed the parties were going to be relitigating decision-making. And just as here, in the motions to enforce the parenting plan and the orders after the motion to enforce, there was sufficient other allegations to say that they were going to be relitigating decision-making because there was allegations that McCubbin was harassing Ms. Goss and questioning her parenting. There was allegations that Mr. Cubbin was making unilateral decisions and that he was refusing to co-parent. And they alleged several examples. So leading up to the hearing, there shouldn't have been a surprise that co-parenting was an issue that was going to be being litigated, it's not an instance where somebody was trying to modify alimony and they came out with a new parenting plan, for example. But this was the issue that's been a problem for the last 2 years. And another point is Smith versus Smith, where the court noted that the test for implied consent is quite broad and really amounts to, is there unfair prejudice to the other party? In other words, was there something preventing the other party from defending the issue or presenting additional evidence? And here, Mr. McCubbin has not alleged a single thing that he was prejudiced by. He has not suggested, in fact, he argued that, yeah, co-parenting is not working, and then made an argument for how he believed it should be fixed. And furthermore, this isn't a situation where a lot of the cases that they cite where it was raised at a one-day hearing and everybody was surprised by it. No, this was actually over a 2-day hearing with a month in between the 2 days, and it was raised at both hearings. So certainly if Mr. McCubbin and his counsel believed that additional arguments or evidence, or there was some surprise was needed to be corrected, there was sufficient time to take corrective action. On a final point, which kind of relates to implied consent, but the case law does seem to treat preservation and implied consent somewhat differently. I will point out that this case is very similar to Ailes versus Bomey, which is a Supreme Court case factually it's different, but procedurally it's right on point. It involves a medical malpractice action involving damages or injuries caused during a surgery. And during the trial, the plaintiff's counsel presented evidence of post-surgery injuries, and at closing argument advocated for damages based on negligence happening after surgery. And opposing counsel objected and that said, hey, there's not sufficient evidence of post negligence injuries. But the court overruled it, let it go onto the jury. This court on intermediate review said that issue of post surgery negligence was not pled or tried by consent. And then in the Supreme Court said, no, the issue of whether or not something was pled or tried by consent was not adequately preserved, because simply objecting, hey, there's insufficient evidence on this, is not objecting to, hey, I didn't prepare for this was not pled and I'm not ready for trial on that. So this is exactly the same situation here, where the issue was raised during either opening or closing and there was no objection. And at final point, this is not fundamental error. One of the cases they rely on for fundamental error was actually a case that we cited, Weiser versus Weiser, which was a case involving a guardian trying to terminate her guardian, her duties. And the court said, and it was involved a situation where the court had ordered return of certain funds that have been transferred. And the court said that, well, there was no objection at trial. So the only way that the return of those funds can be raised on appeal is if there was fundamental error. And in the next paragraph of that case, the court said, and I'm just pulling it up, upon a review of the record, we conclude there was no fundamental error. The court found that there was no fundamental error because there had been a general allegation of these funds being transferred. There hadn't been a request for them to be returned, but there was a general allegation of funds being transferred, and there was a general prayer for relief, any other relief the court deems appropriate and just. And then at the beginning of the hearing, the trial counsel, the movement, asked for return of those funds. And the court said, that's adequate notice. There is no due process violation. Therefore, it's not fundamental error. Therefore,
if I may, Mr. Donovan, and going back to the question that Judge Smith brought out as to what was asked by your client in the opening statement, I actually was trying to pull it up to see. In the opening statement, I think the request was not limited. It was just for ultimate decision making. And as I read the closing, when they requested sole parental responsibility generally, and then said, or at a minimum, trying to give the court an alternative. And so the fact that they did request sole parental responsibility, or at a minimum, these ultimate decision making, extracurricular activity, I think you could read it that, hey, we're asking you for this big thing because both sides agree that co-parenting doesn't work. And I think that's what our analysis, I think we need to look at. Both sides agree this doesn't work, and co-parenting is the same thing as shared parental responsibility. It's not working. What can be done? And so, and the fact, and you brought this up, and I looked at it, it's true. This went over, it was over 2 hearings. There's one on October 31, one on December 6th. So the question for our analysis is that if one party does not believe this issue was brought up, maybe they need to bring an objection to bring into the court's attention that we have issue with that. So this is something I think ultimately will be our focus, in reviewing this as well. But I think, and maybe this question is Mr. Frazier, there's no question, I think, on behalf of this client, that this does not work. And and because this does not work, what needs to be done? And as Judge Smith said, this parallel parenting, that's a new thing. That's just it's a term of art that's not really based on the statute. So this is something that we just have to focus on in this case.
Yes, Your Honor. I agree with your analysis there. Unless there's any other questions, I will release my time back to the court.
Okay, very good. I just want to make sure Judge Smith or Judge Stargell, any questions on that? Very good. Thank you, sir. And Mr. Frazier, you have your 4 minutes for rebuttal, and help me out. And I teed up that question for Mr. Donovan. It's really more directed to you. Help me out. Am I misreading that altogether?
Well, Your Honor, I would like to bring the court's attention to a very telling phrase that opposing counsel mentioned, that being unfair prejudice. One of the cases that we cited in our reply brief did analyze what constitutes unfair prejudice, and that's the Golden v. Bass case. And that is where they had modified residential custody in a petition. The petition had requested that, but it was not noticed for hearing. And notably, both parties presented arguments as to modification at the hearing, despite it not being noticed. But what the first district held is that despite participating in the argument, the appellant was still prejudiced because they did not have the advanced notice that would have allowed them to secure witnesses and procure testimony supporting the argument. And as this panel knows,
I appreciate Mr. Frazier, but that kind of, you're dealing with, it's not a hearing that took place, continuous over a 2-day period. It was a break, October 31, December 6. So after the first hearing, we're like, oh my gosh, this is this issue. Oh my gosh, I better object. Nothing. And it was continuing on that these are the issues that we're facing with. The court delineated in the final judgment all the problems that they're having. I guess I'm struggling. How can your client needs to object? It's something needed to be done, at least to alert the judge that, hey, we're objecting to that. And then the court acknowledged that in the final judgment, saying, hey, this issue was tried by consent. That's where, and I appreciate all the cases that you're citing to, they say what they say, but that's the part that I'm having difficulty with.
I understand the panel's concern, Your Honor, and your concern specifically. I would like to point out that opposing counsel did cite to a number of cases claiming that these are analogous to the situation here. However, they're quite distinguishable. In the Cruz case, where he talks about ultimate decision-making being mentioned by both parties, that was mentioned by both parties in pre-hearing filings, which was not done here. And I understand the concern that this was spread across over 2 days, but this was solely about contempt. The standard for contempt and for modification of parental responsibility are very different. And unlike the cases cited by opposing counsel, this is not a situation where Ms. Goss had brought up parental responsibility or modification thereof in any pre-hearing filing. And the notices of these hearings didn't mention decision-making in any capacity.
Mr. Frazier, but can you not agree that the issue of sole parental responsibility at the very least bled into the testimony because of the complaints and the issues and the conflicts that the parties were having that rose to the level of the contempt issues that were before the court? And so they were both talking about what was working and what wasn't. Can you not at least agree that that same testimony may very well have come up at the supplemental petition hearing?
Your Honor, I do agree with the facts as stated, but respectfully not with the conclusion as given. This was the exact issue that the third district analyzed in the DeCuna case, where the court held that because the issues raised and litigated were relevant to what had been properly noticed, the party's failure to object was not found as implied consent. As Your Honor just stated, these are relevant to both the issues of contempt. Whether or not Mr. McCubbin can cooperate with these experts and whether or not it's helping the familiar relationship is also relevant to the matter of parental responsibility. But because these bits of evidence are relevant to both, Mr. McCubbin's counsel's failure to object to them can't be seen as implied consent for the issue of modification when that was never raised at any point. That's the core holding.
So where was it left with the supplemental petition that was pending? Did the court deal with that in the order, since this issue was tried by consent from the trial court's perspective?
Your Honor, the trial court only dealt with the issues of sole parental responsibility, listing the 6113 factors that it believed supported that determination.
But did the court mention anything about the pending supplemental petition? In that, it's a very lengthy order and it's very detailed because it goes through all of the
Correct.
best interest factors.
And once you
court did not-
respond to that, question, Mr. Frazier, I won't tell you that your rebuttal time is up, but go ahead and
Thank you, Your
respond
Honor.
to Judge Smith.
The order does not specifically mention the pending supplemental petitions regarding time sharing and child support. However, I do note that the trial court did mention that this was intended to be a final order, which I think we can assume implies that this is meant to subsume all those issues.
Okay.
But as Mr. McCubbin did not have an issue with the court's findings regarding time sharing and child support, he only objected by way of a motion for rehearing on the issue of parental responsibility, which had never been raised and which all evidence claiming to support that decision were actually relevant to the issue of contempt, which was properly before the trial court by filing a notice.
Very good. Thank you, Mr. Frazier.
Thank you, Your Honor.
I thank you, Mr. Donovan. Thank you all.